So Friday was the second public hearing up in Chicago with Illinois State Police to have public comments about the firearm registration rules that they filed as part of the Protect Illinois Communities Act, the ban on 170-plus semi-automatic firearms, attachments, magazines. You do not have to register your magazines. I want to make that clear. Illinois State Police have made that clear. But there's still questions about what types of parts that need to be registered. So we heard the highlights from the Springfield hearing last Thursday. Friday morning up in Chicago was the second of 3 hearings, and today down in Caseyville, which I'm going to have to get done here shortly to head down to Caseyville to attend that hearing and to talk with some of the individuals who were there addressing Illinois State Police with their questions. But you had Friday's hearing up in Chicago where they read off some public comments. You hear from a couple of supporters of the measure, and also Todd Vandermeide from Freedom Steel here on YouTube. He was there. But thanks for hanging out with me each and every weekday morning. Bishop on Air. Follow me on X. Follow me on Facebook. Follow me on YouTube. Like, subscribe, hit that notification bell. Let's go ahead and hear some of the highlights from the Chicago public comment period, with public comments being read by Illinois State Police officials.
Is a pistol grip that fits an AR-15 style rifle an assault weapon attachment when it is installed on a bolt-action rifle that is indubitably not an assault weapon. The use of grips designed for AR-15 style rifles on bolt-action rifles is indeed common. What if one swaps grips between an assault weapon and a non-assault weapon?
Yes, a pistol grip is an assault weapon attachment. Again, we refer you to the Illinois State Police website and FAQ number 11.
So a lot of instances of that and more questions that brought about some answers.
Is a safety detent spring that goes into a pistol grip that fits an AR-15 style rifle an assault weapon attachment?
No.
Is a pistol grip screw that is specifically marketed for affixing a pistol grip to an AR-15 style rifle an assault weapon attachment?
No.
Is an AR-15 vice block that holds the lower receiver of an AR-15 style rifle in place while one installs, for an example, a pistol grip, an assault weapon attachment? The vice block clearly attaches to the rifle for the purpose of making such a rifle, and it is specifically designed for this purpose. This seems to meet the language of the PICA as much as any other part.
No, the ISP does not believe that that is an assault weapon attachment.
So you've got, again, questions, specific questions with some specific answers, right? So that was the second public hearing up in Chicago. A few more things that they delved into when it comes to reading off questions that people submitted, which, by the way, you could still submit questions. If you go to the Illinois State Police websites, you can find out how to do that. November 20th is the last day that you could submit those questions, and those questions are... ultimately, they're wanting to have those answered by the next couple of weeks. We'll see if they actually have some answers before the next JCAR hearing in just a few days here. It is Monday, and veto session's back, and I believe they've got a JCAR hearing set for in the days ahead. So we'll see what they have to do with the responses, if any, for November's JCAR hearing. But they said that they'll try to get stuff together by December's JCAR hearing, or maybe after the first of the year. But then the deadline is going to come in for the registration to kick in. And if you don't have your firearms registered and you're found out of compliance, you could face a Class A misdemeanor first offense and a Class 3 felony second and subsequent offenses. More questions that were read into the public record from Friday's public hearing in Chicago.
1. The barrel shroud language. Is a Ranch Model Mini 14 and 1022 legal? 2. Readily convertible magazines. The statute bans magazines that are readily convertible to high capacity. What does this mean? Is a 1022 okay because the handguard is part of the stock? What about something like a Kel-Tec RDB-C or a handmade handguard for a or a handmade handguard for a Fight Light SCR receiver? We need clarification, not just on what guns are fine, but why they're fine and other aren't.
Answers to these questions can be found on the ISP website on the Protect Illinois Communities Act page. Specifically, we would direct you to FAQ number 8. Is a forestock considered a barrel shroud and therefore regulated by PICA? The answer is no. A shroud is not an integral component of the stock, but rather a separate piece. For example, the wooden forestock on a base model Ruger 1022 does not constitute a shroud. Please see the ISP's PICA guide. Other examples of force stocks not constituting shrouds would be the base model M1 Carbine, M1 Garand, and Savage Model 850, assuming they have no other features regulated by PICA and have not been modified to include any regulated features or attachments.
So again, you've got questions and some specific questions referring people back to the frequently asked questions or the guide or whatever the case may be. Obviously, questions persist because this can change every October 1st. If this law is upheld and kept in place, then every October, new rules can be promulgated by Illinois State Police that changes the list of firearms and attachments and things. So you have to constantly be, notified of this. And this is going to be an annual thing. I don't know if the Second Amendment, that's, I guess what's a question is, what does shall not be infringed mean? What does, the right to keep and bear arms mean? What does for the security of a free state mean? What is a well-regulated militia? Kind of going backwards, but the Second Amendment, does it say that you have to check a list with Illinois State Police and check it twice each year? Here's a supporter of this measure from a gun control advocacy group making her statements and public comments in Chicago with Illinois State Police.
Good morning, and thank you for this opportunity to make this statement. And I'd also like to thank the Illinois State Police and their entire staff and troopers for their service in keeping us safe every day. My name is Kathleen Sansis, and I am the president and CEO of the Illinois Gun Violence Prevention PAC, better known as GPAC. We are the largest gun safety organization in the state, and I am here to double down and reiterate our support for the Protect Illinois Communities Act. Since this law was passed and signed into law, gun extremists in the state have waged a merciless disinformation campaign attempting to find new ways to water down this critical legislation or even to do away with it completely. But what we're losing sight of is what even made this law necessary in the first place. We are here because a man armed with a semi-automatic rifle decided to open fire on a crowd trying to enjoy their holiday. 7 people were killed, dozens more were injured, and this is one of the 2 deadliest mass shootings to take place in our state. Enough with the circular debates, the wasteful use of our court systems, and other tactics meant to appease egos and pockets. The law is needed, and it is necessary as is. We are not here to entertain the whims of the gun lobby and their supporters. We are here because we know that when laws like the Protect Illinois Community Act are not left to stand in their entirety, it is our lives and the lives of our children, friends, and neighbors who will be left in the balance. We have seen the devastating consequences of gun violence in our communities and across this country. As we all join here together, the people of Lewistown, Maine are in agony over the rampage caused by a gunman who killed 18 people. Again, I say enough with any attempts to chisel away at a law that will save lives. Let public safety be something we can all get behind, and let it not be a matter that remains open for compromise. Thank you.
I think that's, obviously you hear from the gun control advocates, but on the opposite side, you have those who say that fundamental rights can't be compromised. And you have to accept that. And there's other avenues that you can look at when it comes to addressing violent crime and mental health issues and trying to keep prohibited people from having certain firearms. But we see time and again people, the ball's dropped when law enforcement are provided information about either somebody who has, a mental health issue or is a clear and present danger and so on. But the question of the law being necessary, Gun goes to this balancing of interests, right? Public interest versus fundamental rights. But regardless, Todd Vandermeide, he was there to represent the gun rights groups in his Freedoms Steel YouTube page. He's already shared some of this, but I do want to just provide some highlights from what he had to say, bringing up some interesting points on, the questions about parts and such.
Your statement yesterday directly contradicts the black letter of the law. The law says if you have a combination of parts, and this is an illustration of the types of magazine extension tubes that Mr. Sanders referenced in his comments yesterday, Mr. Witowski referenced yesterday in their comments. I would point out that your statement yesterday flies in the face of the state police's own submission to the federal court in the Southern District of Illinois. Here's a picture of parts. And as such, magazine tubes fall squarely within the combination of parts that can extend or convert, because the state police has offered no definition of readily restored, which means turned back to a condition it once was in, or converted to something it never was but can be made into something different. How do you guys get around the black letter of the law?
The state police has indicated that it will take those comments under advisement and attempt to provide additional clarification in the proposed rules during the first notice process.
Well, since you haven't provided a definition, in the case of Vanderstock v. Garland, argued in the Fifth Circuit Court of Appeals just a few weeks ago, the ATF, which I think we would all recognize as a very technical group when it comes to firearms, sat there and said that they submitted in briefs and footnotes that it's 8 hours of labor with a fully capable machine shop is the standard that they use to evaluate readily convertible or readily restored.
And that information was provided to us yesterday, and it is being taken under advisement and will be considered as part of our corrections or amendments to our proposed rules during this first notice process.
So this is the first notice process for people who haven't really followed how the sausage is made, so to speak. The legislature passes a law, and then there have to be administrative rules from agencies to administer those laws. Typically, they're proposed rules, but for some reason, and this is part of the Southern District of Illinois case that Federal Firearms Licensees of Illinois have brought, questioning why there was an emergency, why state police waited 9 months to file their rules, why? All of a sudden, it's an emergency, and they can have these emergency rules in place for 150 days because emergency rules go into place immediately. Why that instead of having a long process of having where these questions could all be answered and asked for months on end with proposed rules instead of having them as emergency rules? Again, goes to the question of due process and what exactly happened when it comes to the ongoing back and forth of dealing with these issues of the minutia of this, because the minutia is important. You can get caught up and face the possibility of losing your rights if you don't know the detailed minutia of what Illinois State Police are wanting to do. So those are some of the concerns from the gun rights advocates in face of the gun control efforts that are currently in place right now in Illinois. More from Todd Vandermeide.
The black letter of the law that GPAC wrote bans the 1022. And if you look at the 1022 specifically, there is a barrel band around the standard traditional old walnut stock model that connects the barrel to the forend. I don't see how you're going to get around this without a legislative change. And that's how I want to understand, how does the agency defy the black letter of the law?
The Illinois State Police will propose rules to the Joint Committee on Administrative Rules, and it will be up to that committee to determine whether or not the Illinois State Police has exceeded its statutory authority.
Okay, and I see that you quote the FAQs several times in your response to people, and thank you very much. But I have had the argument and discussion on the side of the road with your troopers about gun laws for being pulled over for a speeding infraction. Those FAQs aren't going to hold up when somebody is detained or questioned by a law enforcement officer. You can print those off all you want. And I've actually seen people hand parts of the law, not this law, but other ones, to law enforcement officers. They say, we don't care. You may beat the rap, you ain't going to beat the ride. And that's what I think you have a big problem here, because you haven't defined readily restored, you haven't defined readily convertible, or what any of that means.
So clearly more questions than answers, even after 2 public hearings, a 3rd public hearing down in Caseyville, which just looked at my map here. It looks like I got to get going here in a moment to be able to make it there on time. But Vandermeide wrapping things up from Friday's public hearing, giving you some of those highlights. He went into a little bit of a science fiction land, but with real-world implications.
Since GPAC is all pride in their authorship, along with Mr. Morgan, I just wonder why they hate Star Wars so much. You see, this is a picture of Obi-Wan's lightsaber from the original Star Wars movie. And you know what they used to make that, the prop masters? They actually used a World War I No. 3 Mark I British rifle grenade launcher. They also used a flash hider and booster from an A&M2 50 caliber Browning machine gun. So the question is, as a good law-abiding citizen and Star Wars fan, do I have to register my lightsaber? Because I actually have these parts.
If it meets the definitions in the PICA Act, then it will be subject to regulation and the endorsement affidavit process.
So with that, I think your agency has been put into a position where it can't win, because a group of people who knew next to nothing about firearms or all the intricacies of all these things that they put into a law passed what they wanted with little thought to your agency. And I don't necessarily envy your position that you're in, because you've been handled a big pile of goo to try to fix, because the legislature isn't going to go about and do it. And I think you're in a catch-22 where you're damned if you do or damned if you don't.
So again, Todd Vandermeide from Freedom Steel. We'll have to connect with him in the near future to get more of his thoughts on how all this is playing out. So that's a highlight from Friday's hearing. I'm going to get out of here and head down to Caseyville. We'll bring you highlights from that hearing tomorrow morning here with Bishop on Air, so be sure to stay tuned. Like, subscribe, follow me anywhere. Just search Bishop on Air and click that notification bell, all right? Have yourself a great day. We'll be back here tomorrow morning about 7:30, 7:40 or so, and give you those highlights, and also a preview of veto session. The final 3 days are today here in Springfield at the state capitol. We'll definitely plan on being there as well and give you the latest. So be safe out there, all right? We'll see you here tomorrow.